This is a Momentum Media production.
The SMSF Advisor Show. Your expert insights into the biggest themes shaping the SMSF advice industry.
Hi everyone and welcome to the SMSF Advisor Show. I'm joined by co-host Aaron Dunn, CEO of Smarter SMSF. Hi Aaron.
Hi Miranda, how are you?
I'm good, and yourself?
Not too bad. Budget night was interesting, wasn't it? So usually you have maybe a bottle of wine ready or a six-pack of beer, it might be for me, and you start to churn through legislation and or proposed measures and so forth. And I reckon I got about 2 sips in and I was done.
Yeah, I think it was the earliest night I finished in all the years of doing the budget, which I don't know if it's a good or a bad thing, but probably good for the industry.
Yeah, so generally I think it's a good thing from a stability point of view. Of course, that has been very much at the heart of what the industry wanted for a long time. So yes, nerds like me might want to be able to trawl through stuff and look for things to be able to provide education and training around. But ultimately, having some stability there was a good thing, but not unexpected either, given that we not long from having an election called as well.
Yep, I think they just want to keep things stable, not risk rocking the boat or anything. But we did see a couple of things, I guess, sort of reconfirmed, including that reduction in the minimum drawdown rate.
Yeah, so again, we've seen this extension. So this year one was 1920 when obviously COVID hit, and we saw what was a 50% temporary minimum that was applied in that year. And in essence, we've now had that 50% rolled over again for the 2022-2023 financial year. I guess not only off the back of the backdrop of COVID, but naturally some of the concerns from overseas that we have as well that are pushing up the prices. I guess inflation we're seeing sort of jump up. The cost of petrol is a perfect example of that with the problems that we have overseas. And also the fact that those are regulation changes that need to be made. So they have actually already been registered, and we will see those, as I said, carry on from the 1st of July 2022. And there's some real opportunity in there, I think, for advisors to be talking with their clients about strategies you'll employ where clients may be taking more than that reduced minimum for the year.
The other thing we saw reaffirmed was just their commitment to fixing that ongoing excess issue that some of those legacy pensions have in terms of when they have excess transfer balance amount. And we have actually seen them register those regulations this week.
Yeah, so again, another fix, I guess, that has been hanging around for a long time to try and allow for legacy pensions, so market-linked defined benefit income streams that created an excess transfer balance, and there was no resolution within the regulations to fix these. So we have seen the government now, again, register those regulations that will allow for that excess to be rectified in the relevant scenario.
I suppose a couple of things that I guess you could say were missing from the budget were they didn't really sort of reconfirm those SMSF residency changes and the 2-year exit measure for legacy pensions as well.
Yeah, it's somewhat surprising. I think, if you think about a budget, budgets are all about forward planning. So you would think that would have been re-included in that. Now, it has a negligible impact on consolidated revenue, I guess, so from the government's point of view, but it would have been nice to have seen the government reiterate their stance on that. We may see some announcements around those by the ministers at the SMSF Association conference, where I know both the Coalition and Labor have either senators and or ministers presenting or making comment at the conference around those sorts of things, which we might see. But yeah, to me, it was a bit of a glaring omission to see that the government's saying, well, are we actually still committed to these things or aren't we?
Yeah, that's a good point. They might be waiting for a later moment to announce them rather than them being lost in all the other sort of announcements that happen at budget time.
Yeah, correct.
So in other news that's happened this week, we also heard that the ATO doesn't have any plans to extend that relief it provided around non-arm's length income, specifically relating to expenditure that was provided in that PCG. So that's despite the government's announcement that they're going to look at this area and some of the issues impacting the industry with non-arm's length income.
Yeah, so we saw Senator Hume announce in the lead up to the federal budget that the government has taken on board the feedback from industry around the application of the non-arm's length expenditure provisions. And that was obviously much relief for APRA and the SMSF industry because there are some genuine concerns in its operation. Now, following on from that, we did see the ATO say, well, we do have practical compliance relief PCG 2020/5 in play at the moment, but because the government intends on making these changes effective from 1 July 2022, there is no need in the ATO's view to extend the existing relief that is available, so the safe harbour, beyond this current period, 30 June 2022. Now, the issue may be that this is not resolved by that point in time. We may have a change of government, focus and energy towards that may look very different, but the intention is that if it gets completed further down the track, that it is intended to be backdated to 1 July 2022. That in itself may create a bit of confusion, anxiety maybe in some, because the connection of things like accounting fees or lack of accounting fees for a period of time and the fact that it could taint all the fund's income may just make people nervous for a little bit, but the intention, as the government has indicated, is that it will get backdated to that point in time. So as long as the reforms that they intend on making reach the intended outcomes that we hope would happen, then there shouldn't be any major concern with that relief being finalised at 30 June this year.
And the other sort of thing we saw on the regulatory front was just to do with ASIC, who put out a bit of a release just regarding what compliance activity they've undertaken in terms of SMSF auditors this year so far. And there's been quite a focus on some of those independence issues, particularly the ones that were set out in the independence guide for APES 110, and also issues around like market valuations and making sure that things comply with the in-house asset rules as well.
Yeah, so this is an interesting one because we have been talking even on this podcast and the ATO was a guest on this SMSF Advisor show very early on. And the message has been clear for a long time around the expected changes with the independence rules with APES 110, as you said before. Reading a lot of stuff online, interesting, the suggestion here is that because there's been so much shake-up in the industry, these sort of issues are being picked up for the first time. Therefore, reflecting that there are ACRs or audit contravention reports being issued for certain compliance issues, where in the past the more closely held nature of some of those relationships that did exist may not have been picked up previously. So that makes a lot of sense to me, the fact that there's been rotation in potentially a third of the industry with auditors. There is a far greater focus on that evidence that is required, and therefore the lack of evidence around arm's length dealings, around property and so forth, may have then led to this increase that we're seeing with contraventions.
And today we're going to be focusing on some of the changes that have been happening in terms of electronic execution and other sort of changes around, I guess, modernising everything to do with businesses and SMSFs. Obviously, with the pandemic, that sort of accelerated the government's focus on digitising SMSFs. So Aaron is going to be taking us through some of the changes that have happened and what's on the horizon. Clearly, you're expert in this area, so we're very lucky we've got you to give us a bit of detail on that.
Yeah, pleasure. And I think I've been lucky in so far that, happy to share a little bit today. I was invited through the SMSF Association recently to work with Treasury on some of these modernising business comms. So sort of happy to talk to the opportunity that is presented for us as an industry right now to think about what a technology neutral industry looks like in terms of not only signatures, but around record keeping requirements and the like too.
So just to start off, especially as today is one of the important deadlines for director IDs, could you just explain what the changes are in operation with the new director ID laws that started from November? And just take us through what SMSF professionals should be thinking about with those.
Yeah, so this all started, of course, on the 1st of November last year, where the new director ID laws took effect that provides for a director of a company, and that includes SMSF, so corporate trustees, whereby an individual needs to obtain that director identification number, which is a unique identifier of that director, and they are naturally retained with that forever. Now, what we did see as part of the transition of these laws is some clear dates that must be adhered to. And you rightly raised, Miranda, so today being the 5th of April, we do have new laws that effectively start today that requires a director that is appointed into a role of a new entity that they must have obtained their director ID prior to their consent to act as a director of that entity. Now, between the 1st of November through to today, we did have a period of 28 days after the company was incorporated and that individual had therefore become a director to obtain that director ID through the Australian Business Registry Services, so the ABRS site. So there is this change in scope, and then we have what I call our pre-existing, so our legacy, probably not the right word, it's not that legacy if you're only going back to pre-November last year, but in essence, the cluster that was there that were in existence before the 1st of November, they actually are working through a 12-month transition period at the moment, of which those director IDs need to be obtained by the 30th of November 2022. So what we need to ensure in particular is, advisors might be working with clients at the moment and looking at setting up new funds and requesting that information for the director ID as part of that process, is ensuring that they actually have that ID first. And most importantly, that's something that can't be done by a third party. It's going to require the individual to go through a MyGov ID process and ensure that MyGov ID profile has been set up. They need to go through and gather the identity documents to verify who they are. And once that information has been completed, then you can go through and complete that director ID application. And there's a whole heap of, tips and tricks that you need to be aware of there, mate, so that process should only take, 3, 4 or 5 minutes, whereas there have been other people where there's been, incorrect information at the ATO to be able to sort of marry that off. It might be a different name, for example, due to marriage, that can hold up that entire process. So from that point of view, there are now steps that you need to be doing before you go into an incorporation process rather than after, which has been the case up until this point in time.
Yep. And as you said, it's probably best to get things sort of lined up before you start the actual process for applying for it, I guess.
Yeah. And we're seeing now we have, hundreds, well into the hundreds of companies that are ordered, on a regular basis through our platform. And so little things like checks and balances to make sure that has been obtained first is something that is going to become common practice, or at least some form of acknowledgement that they have obtained that first. And whilst there's no requirement to have that attached anywhere else at the moment, yes, you can put it into your corporate compliance software and so forth. There will be a point of time when once the registry is up and running and fully in effect, that will become part and parcel of that registration process in the first instance. So, as a best practice, we're actually enforcing people on our platform to ensure that they've got the director ID, making it a required field. And if they haven't got it, then you can't order the company. So to me, it's a best practice process.
Yeah. Okay. And moving on to some of the changes happening in the electronic execution space, electronic execution has been popular amongst SMSFs, especially with the temporary measures that were in place during COVID-19. We've seen some of these measures recently become permanent. Can you elaborate a bit on the impact of these changes for electronic execution?
Yeah, so we have been looking at temporary measures, and those temporary measures help get us through the COVID pandemic. And when we look at those measures, we needed to understand measures that were at a state level and measures that were at a Commonwealth level. So from a Commonwealth level, we are naturally looking at the Corporations Act here. And what we had in place in a temporary sense through to the end of March was a set of temporary relief measures around the application of Section 127(1) of the Corporations Act. So if you're a corporate trustee, you would be able to execute in an electronic form through an electronic execution or a modified split execution or some sort of split execution. You'd be able to go through and do that and satisfy the requirements within Section 127. Now, the intention then, once those temporary measures had ceased, is that from the 1st of April, I should say, that those temporary measures would become permanent. And on Richie Benno Day, so the 22nd of the 2nd, 2022, we did see the government pass and receive royal assent the Corporations Amendments, Meeting and Documents Bill, which in essence made those measures permanent. So replace the temporary measures, and then from the 1st of April 2022, the way in which you can sign under the Corporations Act, Section 127(1), as I mentioned before, will allow for a company to be able to execute certain documents, which includes deeds and meeting-related documents in what they are referring to as a technology-neutral manner. So, but it is important to remember that we are here specifically looking at the signing of deeds. In this regard, there are a range of other documents that we will talk about shortly that you need to understand that these measures currently don't apply to. This is simply looking at the way in which meetings can be hosted and the way in which deeds can be executed in accordance with the Corporations Act.
Okay, so this is just, I suppose, one part of
the jigsaw.
Yeah, the jigsaw.
Yeah, absolutely.
Yes, so not all documents can be signed electronically due to the exemptions of the Treasury Law's portfolios with the Electronic Transaction Act. What kind of impact does this have in signing documents, and what changes might be ahead in creating these technology neutrality laws?
Yeah, so what we have at the moment is that a range of Treasury portfolio laws currently are excluded from the Electronic Transactions Act. So, for example, the superannuation laws are excluded from the Electronic Transactions Act from having it applied. There have been, over time, some exemptions that have been introduced, and one that we did see during COVID-19 was Section 35B, which allowed for the use of a technology-neutral process, i.e., by wet ink or through electronic means, to be able to sign the financial statements of an SMSF. But this is where it becomes quite interesting, because if you think about the context of establishing a new fund and establishing it with a corporate trustee, we need to understand the different documents that can be currently signed using electronic means and things that can't. So let's just go through and look at a new fund. We'll have our company set up. We've got our constitution. We've got things like consents to act. We have our SMSF deed. We have the ATO declarations. We have member applications, trustee minutes, and so forth. So the current rules, so the permanent measures for electronic execution, allow for the signing of the deed to be signed in an electronic form. And the constitution is in the same guise as well, where it would require signature. Whereas once we get to things like the consent to act, so either a consent to act as a trustee, which is in the SIS Act, or a consent to act as a director, which is in the Corporations Act, because the SIS Act and the Corporations Act are Treasury portfolio laws that the Electronic Transactions Act does not apply to, those documents must currently be signed in wet ink. So there is no exclusion or exemption for those to be signed in an electronic form as the law currently stands. So the same thing goes with something like an ATO trustee declaration. So Section 104A requires that it must be written, that declaration must be written and therefore signed. So again, the current measures in play do not allow for that document to be signed in anything other than wet ink. Then when you look at member applications or resolutions, which are decisions of the deed, you need to be contemplating what the rules of that fund say to determine what form those documents may or may not be able to be executed in. So it's not a straightforward process at the moment. And I think there'll be a lot of people out in the marketplace that have really adopted the electronic execution measures that says, oh yeah, just let's get everything signed because that's fine. The short answer is not fine at the moment. We are trying to address this as an industry to improve that process going forward. It is creating a little bit of disconnect because auditors and stuff are saying, well, yes, you've done these documents, but they actually haven't been executed correctly. And you go, well, yeah, but they're done. So there's no qualification or any issue that the ATO might have there in regards to, or the auditor may have in regards to a particular document. But if it came down to a court of law to look at particular issues around, well, has that person actually signed off and consented to be a director, and they did it in an electronic form when they were not allowed to, well, then quite clearly the courts may take a very different position.
Okay, so there are, I guess, a few traps still in this kind of area in terms of it depends on what kind of act it relates to, and then there might be different rules for different trustees. So there's definitely some things to be aware of there.
Yeah, absolutely. And this technology neutrality is a big thing that the government is currently working through. So what we do have at the moment is what is called the first stage or first tranche of the technology neutrality reforms that the government is looking to do. This formed part of a Modernising Business Comms paper that they issued in December 2020. And it looked at a broad spectrum of stuff, but it's about how do we bring these Treasury Law's portfolios into the technology neutrality framework. And we did see in February measures get introduced that in essence in the first tranche is addressing this issue with the Corporations Act. So pretty much opening up the Corporations Act to the application of the opening up the Corps Act to the Electronic Transactions Act that would therefore allow for that consent to act as a director, for example, to be done using electronic means. So now there are some issues around or things that need to be considered that are different under these proposed rules versus the Electronic Transactions Act rules around consent and the fact that you'll be able to provide a link to that document rather than having to serve that particular document. But these are all things that Treasury is working through with industry at the moment. And it was something that I was invited to participate with the SMSF Association on recently because SMSFs are going to form part of phase 2.
Okay. Yes. So you met with Treasury recently, and as you said, that those recent laws that were passed are really just part 1. Yep. So as part of that consultation, which involved the SMSF Association regarding the Modernising of Business Communication project, what sort of things might be on the horizon and what impact is that going to have on the SMSF sector?
Yeah, so the first instance is what's being looked at from a communications model is the fact that, and this goes to this first bill that is before Parliament around the Corporations Act. And it goes to the first instance that all documents under the Corporations Act can be signed and or executed electronically. So in principle, that's where we want to get to with the SIS measures. Now, there may be some question marks around testamentary documents. If we think about binding death benefit nominations, should there be a straight-through process that wouldn't necessarily require witnessing to be able to verify who that person is? There are some concerns that have been raised around things like elder abuse and the fact that more advanced technology for a lot of older people in this way may create outcomes that weren't necessarily intended to by opening up for these type of testamentary documents. But by and large, we're looking at things around electronic execution for things that are in the SIS regulation. So if we think about, I spoke before about financial statements, which were already spoken about. Auditor requests is an issue. You have things like within the in-house asset rules, whereby Section 82 requires a written plan to be provided. So it cannot be done in any other form other than in wet ink as it currently stands. We have requirements around the duty to keep minutes and records. So we have 5 years, we have 10-year requirements, and there's an opportunity here to think about timeframes of retention for certain documents, even where we think about decisions around changes of trustees and other things that require a minimum of 10 years in an electronic timeframe. Should there be something that requires that to be presented for much longer? Other documents that may be for much shorter? Do we need 5 years and 10 years? These are all things that are going to come up for discussion as part of this process. And the one thing that I've actually found quite interesting was around the investment strategy requirements, because as it currently stands within SIS Reg 4.09, there is no formal requirement to actually have to have a written investment strategy. So when you think about its application in the marketplace, the ATO makes it very clear in their literature that we need to have, or the expectation is that there is a written strategy. There may be some advisors or practitioners that when it goes to audit, they say, well, there's nothing within the regulations that require a written investment strategy. But the auditor, quite rightly, will come back and go, well, I can't audit your head. I can't audit what's in your brain. So it needs to be put down in paper. So again, there's an opportunity here to tidy up some legislative disconnect to ensure that in SIS Reg 409, if the expectation, the requirement should be that it needs to be a written investment strategy, we should tidy that up at the same time, which therefore means we come back to this same issue that we've spoken about with the other SIS measures that would need to ensure that the Electronic Transactions Act would open up and allow for that to be done in electronic means rather than simply in wet ink.
Yeah, so hopefully some of those inconsistencies or grey areas between different sort of laws and regulations can sort of be tidied up a bit.
Yeah, and I think the SMSF Association has been pretty open in their support of these measures. I know with their submission, they were definitely supportive of any removal of the legal impediments to ensure that we're able to adopt current and future technologies as and when required. So, as I said, this next phase is going to be really important with the way in which this can play out with SMSF. So, if there are areas of interest with our audience on the views in particular with record keeping requirements and the costs and stuff associated with those, you can always email the SMSF Association. I think it's submissions@smsfassociation.com, and you can share any data or figures and stuff that could be potentially utilised in that response, because there is some further follow-up that is happening in that space around a formal response back to Treasury, although they are naturally going into caretaker mode shortly. So I'm sure this will bob up again as we move beyond the first half of this calendar year.
Now, you're going to be speaking about this in depth as well at the upcoming SMSF Association National Conference. So if anyone wants to hear further details on any of those topics, they can definitely join your session then.
Yes, it's Friday morning, 9:00. So good luck getting up. No, they should be fine. But it is. It's going to be a very interesting part of the industry going forward. As I said, as we move to a far more digitised way in which we can manage our clients. At the moment, we've been dealing with temporary measures. We've been dealing with measures that, with all good intention, that's where we're leading to, but understanding the nuances of how the laws do and don't apply at this point in time. Like I said, right across the different Treasury Laws portfolios, what happens on a state-by-state basis. We didn't even really talk about individual trustees as well, because quite clearly they are measures that relate to the Corporations Act. So we're talking about corporate trustees. So these are all things, yes, I'll be talking about in my session at the SMSF Association Conference. So come along and make sure you say good day.
Okay. Thank you for taking us through all those different changes. Was there anything else you wanted to mention today?
No, I think that is pretty much it. Like I said, there is a lot of activity that is clearly going on at the moment. Much of it in the technology sense has really accelerated off the back of COVID, but this pace of change really isn't going to go away, and therefore keeping up to date with these things, like we said from the very beginning, the different timings that apply with your clients around the new director ID laws is just one example of what's going on there. And, we'll use these sort of forums on the SMSF Advisor Show to keep you up to date with other advancements as we go along. So, which probably leads me to ask you, Miranda, if people do have any questions around topics or speakers that they'd like to hear on the show, how can they get in contact with us?
Yeah, so they can get in touch with us at editor@smsfadvisoronline.com.au. And thanks everyone for listening in. And yes, if you have any suggestions or topics you want to hear about, just let us know.
Excellent. Thank you everyone once again for joining us on our SMSF Advisor Show. Take care and bye for now.